This is HOA Citation Circus. It started with a fence line and ended with a board meltdown. I am standing in my side yard in Winnipeg, Manitoba, holding a bright orange cone in one hand and a survey stake in the other, and Brenda Jones is screaming at me that I have committed trespass on HOA common property and she will fine me $500 if I do not remove the stake right now. The stake is 6 inches into my own yard. The survey report is in my back pocket. She does not care. My name is Daniel. I am a safety compliance officer. I write incident reports for a living. I moved to Winnipeg 2 years ago for a regional promotion, and I bought a house in a subdivision called the Cottages at Willow Glen because the listing promised low HOA dues and minimal restrictions. That was a lie. The HOA here is a selective enforcement machine. The moment you try to improve anything, they ramp up pressure like you insulted their ancestors. The design review board is run by Brenda Jones, vice chair, and she treats covenant enforcement like a personal crusade. I decided to replace my sagging chain link fence with a new privacy fence. 6-foot cedar panels, posts set in concrete, clean and modern. I pulled the covenants, read every word, confirmed the height limit is 6 feet, confirmed setback is 12 inches from the property line. I hired a licensed surveyor to mark the line so I would not make a mistake. That survey stake, that little plastic flag on a metal rod driven into the grass 3 feet from my driveway, is what started this war. Brenda showed up 10 minutes after the surveyor left. She parked her sedan across my driveway, got out with a clipboard and a roll of caution tape, and marched across my lawn like she owned it. She planted herself in front of the stake, pointed at it, and said, "That is HOA easement. You do not have authority to mark it. Remove it now or I will cite you for unauthorized alteration of common property." I pulled out my phone and opened the survey report. I said, "This is 12 inches inside my property line. The surveyor is licensed. The report is dated today. This is not your easement." Brenda did not even look at the phone. She said, "You signed the covenants, now you live the covenants. The design review board has not approved your fence. You do not touch the ground until we approve the plan. That stake is evidence of intent to violate setback. Remove it." I said, "The covenants say 12-inch setback. I am in compliance. I submitted my design review application 3 weeks ago and I have not heard back. My contractor starts tomorrow and the permit inspection is scheduled for this afternoon. If I miss that inspection, I lose the permit and the contractor charges me a rescheduling fee. I am not removing the stake." She smiled. She said, "Keep arguing. You are making my case for me." Then she turned, walked back to her car and drove off. 10 minutes later I got an email from the HOA management company. Subject line, "Violation notice, unauthorized site work." Body, "Cease all activity immediately. Attend mandatory design review hearing on Thursday at 7 p.m. Failure to attend will result in automatic fine of $500 and amenities lockout." I let her say my name loud, because later I wanted it on the recording. That was Monday. By Wednesday my contractor called and said he could not start. He said Brenda had contacted him directly, told him the job was under HOA review and any work performed would be considered unpermitted and subject to forced removal at owner expense. He said, "Look, I do not want to get pulled into HOA drama. Call me when you get clearance." I was trying to refinance. Any lien threat could wreck the deal. The bank had already ordered the appraisal and the underwriter was waiting on the final inspection. I could not afford delays. I could not afford fines. I called the surveyor and asked him to send me a sealed copy of the plat. I called the city and confirmed my fence permit was valid and active. I called a real estate attorney in Winnipeg and paid $200 for a 30-minute consult. He said, "If the HOA blocks a compliant project, that is selective enforcement. Document everything. Record the hearing if Manitoba law allows it. Get their reasoning on the record." Thursday evening I showed up at the HOA clubhouse. The design review board meets in a side room with bad lighting and folding chairs. Brenda was already there, sitting at the head of a long table with two other board members. One of them was a calm homeowner named Marcus who I had seen at neighborhood events. He always carried a printed copy of the covenants in a binder, and he loved reading them out loud when someone made a bad ruling. He nodded at me when I walked in. Brenda opened the meeting. She said, "We are here to review an application for a 6-foot privacy fence on Lot 42. The applicant has already violated protocol by placing survey markers on common property without board approval. We are considering a stop work order and a fine for unauthorized site alteration." I said, "The survey stake is on my property. I have the plat. I submitted my application 3 weeks ago, and I still do not have a response. My permit expires in 2 weeks. I need approval tonight, or I lose the contractor." Brenda said, "We received your application. It is incomplete. You did not include a site photo showing the proposed fence line in relation to existing structures." I pulled out my phone and opened the photo. I said, "I attached it to the email. Here it is. Do you want me to forward it again?" She waved her hand. She said, "We are also concerned about the style. Cedar panels are not listed in the approved materials appendix. You will need to submit a variance request." Marcus flipped a page in his binder. He said, "Brenda, the approved materials appendix lists wood, vinyl, and metal. Cedar is wood. That is compliant." Brenda shot him a look. She said, "The appendix specifies pressure-treated pine. Cedar is not specified." Marcus said, "The appendix does not restrict wood species. It says wood. Cedar is wood. He is compliant." Brenda tapped her pen on the table. She said, "Fine. The style is acceptable. But the setback is still under review. We need to verify the survey before we can approve placement." I said, "The surveyor is licensed by the province. The plat is sealed. The city accepted it for the permit. What more do you need?" She leaned back. She said, "The HOA retains the right to conduct an independent verification if there is reason to believe the property line is disputed. We have received a complaint from a neighbor that your proposed fence encroaches on a shared drainage easement." That was a lie. I knew it was a lie. There is no drainage easement on my lot. The plat shows it clearly. I said, "Who complained?" She said, "Complaints are confidential. You will be notified when the verification is complete. Until then, no work may begin." I said, "How long will that take?" She said, 2 to 4 weeks. I stood up. I said, "My permit inspection is in 3 days. If I do not start this week, I lose the contractor and I have to reapply for the permit. You are blocking a compliant project to run out the clock." Brenda smiled. She said, "You signed the covenants, now you live the covenants." Meeting adjourned. Marcus caught me in the parking lot. He said, "She is doing this on purpose. She blocked the last 3 fence applications the same way. She invents procedural delays until people give up, or the contractor walks. She has been running the design review board like a personal fiefdom for 2 years. No one challenges her because she threatens amenities lockout, and people do not want to lose pool access." I said, "What can I do?" He said, "Document everything. Record the next meeting if you can. Get her reasoning on the record. If she admits she is blocking you for personal reasons, that is selective enforcement, and the management company will have to step in." I went home and called the contractor. I explained the situation. He said, "Look, I have another job starting next week. If you do not have clearance by Monday, I have to bump you to the end of the month. That puts you past your permit expiration. You will have to reapply." I called the city permit office. I explained the HOA delay. The clerk said, "Your permit is valid. If the HOA is blocking you, that is a civil issue. We cannot extend the permit without a reapplication and a new fee." I was stuck. I had a valid permit, a compliant design, a licensed survey, and an HOA board that was inventing delays to kill the project. I needed proof that Brenda was acting in bad faith. I needed her to admit it on the record. Friday morning, I got another email from the management company. Subject line: Violation notice. Unpermitted site marker. Body: the survey stake placed on Lot 42 is in violation of Section 12.3, unauthorized alteration of common property. Fine of $250 assessed. Remove the stake within 48 hours or an additional fine of $250 will be applied. If this HOA insanity sounds familiar, hit the like button and subscribe for more stories of covenant chaos. I printed the email. I printed the survey plat. I printed the covenant section they cited. Section 12.3 says, no owner shall alter, damage or remove any common property landscaping, signage or infrastructure without prior written approval of the board. A survey stake on my own property is not common property. It is not landscaping. It is not signage. It is not infrastructure. The fine was bogus. I called the management company. I got a recorded message. I left a voicemail. I said I am disputing the fine. The survey stake is on my property, not common property. I have a sealed plat. Please confirm receipt of this dispute and provide a hearing date. No response. Saturday morning, I was in my side yard inspecting the fence line when a car pulled up. It was not Brenda. It was a neighbor I had seen a few times at the mailbox cluster. Her name was Karen. Not the HOA antagonist, just an unfortunate name. She got out and walked over. She said, "Hey, I heard you are putting in a fence. Brenda asked me to keep an eye on your yard and let her know if you start digging." I said, "She asked you to spy on me?" She shrugged. She said you were trying to install an unpermitted fence and she needed documentation for the hearing. I figured you should know. I said, "The fence is permitted. The city approved it. The design is compliant. Brenda is blocking it because she does not like me." Karen looked uncomfortable. She said, "Look, I do not want to get involved. I just thought you should know she is watching." Then she left. I realized Brenda was running a parallel pressure campaign. She was not just blocking the official process. She was recruiting neighbors to create a hostile environment. I needed to move faster. Monday morning, I drove to the HOA management company office. I walked in and asked to speak to the property manager. Her name was Diane. She was polite but guarded. I said, "I am being fined for a survey stake that is on my own property. I submitted a compliant fence application 3 weeks ago and I have not received approval. My contractor cannot start and my permit is expiring. I need someone to review this and override the board." Diane pulled up my account. She said, "I see the fine. I see the violation notice. I see the hearing record. The board has the authority to assess fines for covenant violations. If you want to dispute the fine, you need to request a formal hearing with the full board." I said, "The board is the one issuing the bogus fine. They are blocking my project to retaliate because I challenged the violation. This is selective enforcement." She said, "Do you have evidence of selective enforcement?" I said, "I have proof that my design is compliant. I have proof that the survey stake is on my property. I have proof that the board member who issued the violation has a personal agenda." She said, "If you believe the board is acting improperly, you can file a complaint with the board president and request an independent review. But I cannot override a board decision without cause." I left the office and sat in my car. I needed a trump card. I needed something that would force the board to back down. I pulled out my phone and opened the HOA Covenant PDF. I read Section 12.3 again. Then I read Section 15, which covers board authority. Section 15 says, "The board may assess fines only for violations clearly defined in the covenants. Any fine assessed without a corresponding covenant violation is void and subject to immediate refund." The survey stake fine had no corresponding covenant violation. Brenda had cited Section 12.3, but that section only covers common property. My property is not common property. The fine was void. I drafted an email to the management company. I cited Section 15. I demanded an immediate refund of the $250 fine and a written retraction of the violation notice. I attached the survey plat and the covenant PDF. I copied the board president and the full board. I sent it Monday afternoon. Tuesday morning I got a call from Brenda. She said, "You need to stop harassing the management company. Your fine is valid. If you continue to dispute it, we will escalate to a lien." I said, "The fine is void. Section 15 requires a corresponding covenant violation. You cited Section 12.3, but my property is not common property. You have no basis." She said, "We have reason to believe the survey is inaccurate. Until we verify the property line, the stake is in dispute. The fine stands." I said, "You are inventing a dispute to justify a bogus fine. That is bad faith. I have proof." She laughed. She said, "What proof? You have a survey you paid for. That is not independent verification. We have the authority to require a second opinion." I said, "Fine. Order a second survey. But until you do, the fine is void and the project is approved. I am starting work tomorrow." She said, "If you start work without board approval, we will issue a stop work order and fine you $500 per day until you cease activity." I hung up. I called the contractor and told him to start Wednesday morning. I said, "The HOA is threatening a stop work order, but I have a valid permit and a compliant design. If they try to interfere, I will handle it. Just get the posts set before they can escalate." He said, "You are putting me in a tough spot. If they issue a stop work order, I am liable for continuing unpermitted work." I said, "The work is permitted. The city approved it. The HOA does not have authority to override a city permit." He sighed. He said, "Okay. But if they show up, I am walking off the job until you sort it out." Wednesday morning the crew arrived. 2 guys with a post hole digger, a bag of concrete, and a pickup truck full of cedar panels. They started marking the post locations along the survey line. The orange cone sat beside the survey stake like a boundary marker. Everything was clean, measured, and compliant. Brenda showed up 20 minutes later. She parked in front of my house, got out with a clipboard and her roll of caution tape, and marched straight to the crew. She said, "Stop. This project does not have HOA approval. You are in violation of the design review covenants. If you continue, the homeowner will be fined and you will be held liable for removal costs." The lead contractor looked at me. I walked over. I said, "The project is approved by the city. The HOA does not have authority to issue a stop work order. Continue the job." Brenda stepped in front of the post hole digger. She said, "I am issuing a formal stop work order on behalf of the cottages at Willow Glen HOA board. Any work performed after this moment is unpermitted and subject to forced removal at owner expense." She unrolled the caution tape and stretched it across the fence line. The contractor dropped the post hole digger. He said, "I am not getting in the middle of this. Call me when you have it sorted out." He and his crew packed up and left. I stood there holding the orange cone and staring at Brenda. She smiled. She said, "You signed the covenants, now you live the covenants." Then she took a photo of the survey stake and the disturbed dirt where the crew had started digging. She said, "This will be evidence at the hearing. Expect a fine notice by end of business today." I went inside and called the attorney. I said, "She issued a stop work order in front of my contractor and forced him off the job. My permit expires in 10 days. What are my options?" He said, "If the HOA is blocking a compliant project, you can file a complaint with the Manitoba Residential Tenancies Branch or take them to small claims court for interference. But that takes time. The faster option is to escalate within the HOA. Request an emergency hearing with the full board and present your evidence. If the board president sees that Brenda is acting outside her authority, He might override her. I said, what if the board president backs her up? He said, then you file a complaint with the management company and threaten a lawsuit. Most management companies do not want litigation. They will pressure the board to settle. I spent Wednesday afternoon drafting a formal complaint. I cited Section 15. I cited the survey plat. I cited the city permit. I cited the contractor blacklist moment where Brenda threatened my crew. I attached photos of the survey stake, the orange cone, the caution tape, and the disturbed dirt. I sent the complaint to the management company, the board president, and Brenda. I requested an emergency hearing within 48 hours. Thursday morning I got a response from the board president. He said, we will schedule a full board hearing for Monday evening. In the meantime, the stop work order remains in effect. Do not resume activity until the board has reviewed your complaint. I called the contractor and explained. He said, I cannot hold the crew past Monday. If you do not have clearance by then, I have to move on to the next job. You will have to find someone else. I called the permit office and asked if I could extend the deadline. The clerk said, not without a reapplication. If you miss the inspection window, the permit expires and you start over. I was out of time. I needed the hearing to go my way on Monday or the project was dead. Friday afternoon I got another email from the management company. Subject line: legal notice, frivolous small claims filing. Body: the Cottages at Willow Glen HOA Board has filed a claim in small claims court seeking reimbursement of legal fees and administrative costs associated with your repeated violations and harassment of board members. You are required to appear in court on the date specified in the attached summons. They were escalating. Brenda was not just blocking the fence, she was trying to force me into court and make me spend money on legal defense. The claim was bogus. I had not violated anything. I had not harassed anyone. But I would have to respond to the summons, and that meant hiring an attorney and losing more time. I called the attorney again. He said, this is retaliation. They are using the legal system to punish you for challenging the board. You can file a counterclaim for abuse of process, but that turns this into full litigation. The cheaper option is to settle. Offer to drop the fence project in exchange for them dropping the claim. I said, I am not dropping the fence. I spent $2,000 on the permit and the survey. I am not walking away because they filed a frivolous lawsuit. He said, then you need to win the hearing on Monday and use that as leverage to get them to drop the claim. If the board overrides Brenda, the claim falls apart. I spent the weekend preparing. I printed every email. I printed the survey plat. I printed the city permit. I printed the covenant sections. I printed the timeline showing 3 weeks of delay. I printed Marcus's notes from the first hearing. I burned it all onto a thumb drive and made a backup. Saturday evening I was checking my mailbox at the shared cluster when Marcus walked over. He said, I heard about the small claims filing. Brenda is out of control. She has been running a community safety committee like a private police force with no authority. She recruits neighbors to report violations, and she uses the reports to justify fines. She has been doing it for 2 years and no one challenges her because they do not want to be the next target. I said, how do I stop her? He said, you need to get her on the record admitting that she is blocking your project for personal reasons. If you can prove selective enforcement, the management company will have to step in. The board president does not want a lawsuit. If you give him a way to override Brenda without losing face, he will take it. I said, how do I get her to admit it? He said, she is arrogant. She thinks the board will always back her up. If you ask her a direct question in the hearing, she will answer it honestly because she does not think it matters. Record the meeting if Manitoba law allows it. Get her to say the quiet part out loud. Monday evening I arrived at the clubhouse early. I set my phone on the table in front of me, opened the voice recorder app, and hit record. Manitoba is a one-party consent jurisdiction. I could record without telling anyone. Brenda walked in 5 minutes later with the board president and 2 other board members. Marcus was already sitting at the table with his binder open. Brenda gave me a cold look and sat down. The board president opened the meeting. He said, "We are here to review a complaint filed by Daniel regarding a stop work order issued by the Design Review Board. Daniel, please present your evidence." I opened my folder. I said, "I submitted a compliant fence application on October 2nd. The design meets all covenant requirements. Height is 6 feet, which is within the limit. Setback is 12 inches, which is compliant. Material is cedar, which is wood, which is listed in the approved materials appendix. I hired a licensed surveyor to mark the property line. The city issued a permit based on that survey. The Design Review Board delayed approval for 3 weeks, then issued a stop work order when I attempted to begin work. The stop work order has no basis in the covenants. The board has also assessed a fine for the survey stake, which is on my property, not common property. The fine cites Section 12.3, but that section only applies to common property. The fine is void under Section 15. I am requesting that the board overturn the stop work order, retract the fine, approve the fence application, and drop the small claims filing." Brenda interrupted. She said, "The applicant has been combative and uncooperative from the beginning. He placed a survey stake without notifying the board. He contacted his contractor before receiving approval. He refused to remove the stake when directed. He accused me of selective enforcement in front of the Design Review Board. He sent harassing emails to the management company demanding an override. His behavior is disruptive, and he is using this hearing to avoid accountability." I said, "I placed the survey stake on my own property after hiring a licensed surveyor. I contacted my contractor because I have a permit deadline. I refused to remove the stake because it is not a violation. I accused you of selective enforcement because you are blocking a compliant project for personal reasons. And I sent one email to the management company requesting a review. That is not harassment. That is following procedure." Brenda said, "You are twisting the facts. The Design Review Board has the authority to verify surveys when there is a dispute. We have received a complaint that your fence may encroach on a shared drainage easement. Until we verify the line, the project is on hold." I said, "Who complained?" She said, "That is confidential." I said, "There is no drainage easement on my lot. The plat shows that clearly. You are inventing a dispute to delay the project. Why?" She leaned back. She said, "Because you do not respect the process. You want to do whatever you want and ignore the rules. This community has standards. If I approve your project, every other homeowner will think they can bypass the Design Review Board and do whatever they want. I am not setting that precedent." I let the silence hang. Then I said, "So you are blocking my project to send a message to other homeowners?" She said, "I am enforcing the covenants to protect property values." I said, "By blocking a compliant project?" She said, "By making sure people follow the process." I looked at the board president. I said, "She just admitted she is not blocking my project because of a covenant violation. She is blocking it to enforce compliance with a process that is not in the covenants. That is selective enforcement. That is bad faith. That is retaliation." The board president shifted in his chair. He said, "Brenda, did you verify that there is a drainage easement on his lot?" Brenda hesitated. She said, "We have not completed the independent survey yet." He said, "Did you order an independent survey?" She said, "Not yet." He said, "Then on what basis did you issue the stop work order?" She said, "On the basis that the project is under review and the applicant has been uncooperative." Marcus opened his binder. He said, "Section 9.2 says the Design Review Board must respond to an application within 30 days. It has been over 30 days. Section 9.4 says that if the board does not respond within 30 days, the application is deemed approved." Daniel's application was submitted on October 2nd. Today is November 4th. That is 33 days. His project is automatically approved under the covenants. Brenda's face went red. She said that is a technicality. Marcus said, "It is the covenant. You wrote it." The board president looked at me. He said, "Do you have your application receipt?" I pulled out the email. I said, "Here. Submitted October 2nd at 4:32 p.m. I have the timestamp." He sighed. He said, "The application is approved. The stop work order is overturned. The fine is void. Daniel, you may proceed with your project. Brenda, we need to discuss your handling of this matter in executive session." Brenda stood up. She said, "This is not over. You are going to regret this." Then she walked out. The board president looked exhausted. He said, "I apologize for the delay. The management company will issue a written retraction of the violation notice and refund the fine within 5 business days. The small claims filing will be dropped. If you have any further issues, contact me directly." I left the meeting and sat in my car. I pulled out my phone and stopped the recording. I had 42 minutes of audio. Brenda admitting she blocked the project to enforce process. Brenda admitting she had not ordered a second survey. Brenda admitting she issued the stop work order without a covenant basis. It was all on tape. I called the contractor. I said, "I have approval. Can you restart the job?" He said, "When?" I said, "Tomorrow." He said, "I will see if I can move the crew. Give me until morning." Tuesday morning the crew arrived. They set the posts in concrete stretched string lines between them and started installing the panels. The orange cone sat beside the survey stake like a trophy. By Wednesday afternoon the fence was up. Clean, level, 6 feet tall, 12 inches from the property line. Compliant in every way. Thursday morning I got an email from the management company. Subject line: Retraction of violation notice. Body: The cottages at Willow Glen HOA Board has reviewed the violation notice issued on October 28th and has determined that the survey stake on Lot 42 is not in violation of Section 12.3. The fine of $250 has been voided, and a refund check will be mailed within 5 business days. The stop work order has been lifted, and the fence application is approved. We apologize for the inconvenience. Friday morning I was inspecting the fence when Marcus walked over. He said, "You did it. Brenda is done." The board president called an emergency meeting last night and removed her from the design review board. She is still on the HOA board, but she does not have approval authority anymore. He also issued a memo clarifying that the 30-day automatic approval rule applies to all design review applications going forward. You force them to follow their own rules. I said, "What about the small claims filing?" He said, "Dropped." The board attorney advised them that the case had no merit and continuing would open them up to a counterclaim. They are cutting their losses. I said, "What about Brenda?" He said, "She is furious. But she does not have the votes to retaliate anymore. The board president is watching her. If she tries to target you again, he will remove her completely." Saturday afternoon I was at the mailbox cluster when Brenda pulled up. She got out and walked over. She did not say anything. She just stared at me. I held up the orange cone. I said, "I kept this as a souvenir. Thanks for the motivation." Her face went red. She said, "You think you won. You did not win. You just made an enemy." Then she got back in her car and drove off. Marcus was standing nearby. He said, "She is not going to let this go. Watch your back." I said, "Let her try. I have the recording. If she comes after me again, I will file a complaint to the management company that triggers discipline. One more stunt and she is off the board completely." He smiled. He said, "You played it perfectly. You let her hang herself with her own words. That is how you beat a bully. You make them think they are winning until the moment they lose." Monday morning I got a call from the board president. He said, I want to apologize again for the way this was handled. Brenda overstepped her authority and we are taking steps to prevent it from happening again. As part of that process, we are issuing a directive that all board members must stop contacting homeowners directly regarding violations. All communication will go through the management company going forward. This is to prevent personal conflicts and ensure fairness. I said, "Does that mean Brenda is not allowed to contact me?" He said, "Correct. If she contacts you directly, report it to me immediately and we will take action." I thanked him and hung up. I realized I had won on every front. The fence was up. The fine was refunded. The small claims case was dropped. Brenda was removed from the design review board. The HOA issued a memo clarifying the rules she weaponized. And she was ordered to stop contacting me directly. It was a clean sweep. Tuesday afternoon, I was sitting on my back patio when I got a text from Marcus. It said, "Brenda just resigned from the HOA board. She sent a mass email to all the homeowners saying the board president forced her out because she was the only one willing to enforce the rules." No one responded. "People are tired of her. You broke her." I did not feel bad. Brenda had tried to ruin my project, cost me money, waste my time, and weaponize the HOA process to punish me for standing up to her. She had recruited neighbors to spy on me. She had blacklisted my contractor. She had filed a frivolous lawsuit. She had done all of it with a smile and a smug sense of authority. And in the end, her own words, recorded on my phone, had destroyed her credibility and forced the board to act. Wednesday morning, I was checking the fence line when the neighbor who Brenda had recruited walked over. She said, "I heard what happened. I wanted to apologize. I should not have agreed to watch your yard. I did not realize she was using me to harass you. I am sorry." I said, "It is okay. You were not the problem. She was." She said, "A lot of people are relieved she is gone. She made this place feel like a surveillance state. Maybe now we can just live here without worrying about who is watching." I agreed. The cottages at Willow Glen had always been a nice neighborhood. The problem was never the covenants. The problem was Brenda, and now she was gone. The fence is still standing. The survey stake is still in the ground. The orange cone is on my patio table. Every time I see it, I remember the moment Brenda stood in my yard and screamed that I had committed trespass. I remember her smug smile when she issued the stop work order. I remember her saying, "Keep arguing, you are making my case for me." And I remember the look on her face when Marcus read the covenant out loud and the board president overturned her ruling. Her smug smile vanished when the room turned on her. That was the moment I knew I had won. Not because I beat her in a fight, but because I let her beat herself. I let her overreach. I let her say my name loud. I let her hang herself with her own rules. And when the time came, I handed the board president a clean packet of evidence and watched him do the rest. The HOA issued a memo clarifying the rule Karen weaponized. She was ordered to stop contacting me directly, and I filed a complaint to the management company that triggered discipline. It was not revenge. It was accountability. And it felt good. Thanks for watching. I will see you in the next HOA story.